How can jointly owned property avoid probate? Have you ever wondered how some people manage to pass on their property without going through the lengthy probate process? Let's talk about jointly owned property and how it can help avoid probate, especially in the context of estate planning and estate tax exemptions. Jointly owned property can avoid probate when it is held in specific ways. One common method is through joint tenancy with rights of survivorship. This means that if one owner passes away, the surviving owner automatically takes full ownership of the property. This transfer happens outside of probate court, which simplifies the process significantly. For this to work, the property's title or deed must clearly state that it is held as joint tenants with rights of survivorship. In some cases, married couples may use a form of ownership called tenancy by the entirety. This form allows the surviving spouse to inherit the property without going through probate as well. Another option for married couples in certain states is community property with right of survivorship. This works similarly to joint tenancy, ensuring that the surviving spouse automatically receives the property without the need for probate. However, not all forms of joint ownership avoid probate. If property is held as tenants in common, each owner's share will pass according to their will or state intestacy laws. This means that the share would go through probate, which is not the desired outcome for many families. Joint ownership can apply to various assets, including real estate, bank accounts, and investment accounts. For bank and investment accounts, adding a payable on death or transfer on death designation can also help bypass probate. However, this is a different approach from joint ownership. From an elder law and estate planning perspective, using joint ownership with rights of survivorship can be a straightforward way to ensure that a spouse or family member receives property quickly and privately. However, there are some limitations to consider. Adding a co-owner, especially someone other than a spouse, may expose the property to that new owner's creditors or legal issues. It can also impact Medicaid eligibility and estate tax planning, since the entire value of the property may be included in the surviving owner's estate for tax purposes. Therefore, it is essential to think carefully about who you choose as a co-owner. In practice, many families use joint ownership alongside other tools to avoid probate, such as revocable living trusts and beneficiary designations. A living trust can provide more control and flexibility, especially for more complex estates or when minimizing estate taxes is a priority. Regularly reviewing ownership documents is also important. Life events like marriage, divorce, or the death of a co-owner may requiring updates to ensure that the property passes as intended. Consulting with an elder law or estate planning attorney can help you determine the best strategy based on your unique circumstances, including estate tax implications and long-term care planning. In summary, jointly owned property can avoid probate when held as joint tenants with rights of survivorship, tenancy by the entirety, or community property with right of survivorship. The transfer to the surviving owner happens automatically, outside of court. By paying attention to the form of ownership and keeping estate plans updated, you can achieve both probate avoidance and alignment with broader estate and tax planning goals.